Morning, Mr. Gunn.
Good morning. Thank you, my lady. My lady, having, I hope, yesterday established the continued relevance of the Commission's arguments in relation to the grounds of appeal and cross-appeal, notwithstanding the annulment of the decision by the court, I turn to consider those arguments as expanded upon in the parties' written cases. As a general observation, we would submit that the misfortune of the Miculas, albeit a self-induced one, is that their case runs up against some of the most fundamental of the Court of Justice's concerns about the effective application of EU law by national courts. And those constitute formidable, and we would submit insuperable, obstacles to the Miculas, both on stay and security. So starting first with stay, the leading authority of the Deutsche Lufthansa case has been prominent in all of the proceedings from first instance onwards, and it's already fully addressed in the written cases. All I think I need do today is draw your Lordship's attention to the endorsement of the Lufthansa principle by the Grand Chamber of the Court of Justice in the City of Lübeck case, which is in the authorities. It's one of the newer ones in Bundle 14, tab 211. That's in the supplementary electronic file, page 419. This is a case where a party did challenge the Commission's decision initiating a formal investigation. The Commission had initiated an investigation into airport charges at Lübeck Airport, which at the time of the initiation was at least partially owned by the City of Lübeck, and then it subsequently was fully privatized. Lübeck, however, had challenged the Commission's decision, and the Commission sought to reject the challenge preemptively, saying that Lübeck lacked standing once it had divested itself of its interest in the airport, since once the airport was in private hands, even if the airport charges did confer an advantage on some airlines over other airlines, it wouldn't be from state resources, and so the standstill obligation arising from the initiation of the formal investigation was meaningless vis-à-vis the City of Lübeck. And the court will see from the title page on page 419, this is a judgment of the Grand Chamber of the court. And all I think I need to do is take the court to paragraph 29, where you will see there is a full endorsement of the Deutsche Lufthansa principles, from which the court continues paragraphs 30 and 31.
Give me the MS number, please.
I'm sorry, my lord, that's 424. Page 424.
Thank you.
The court continues at paragraph 30 to say, the obligation to suspend the implementation of the measure in question is not the only legal effect of a decision to initiate the formal investigation procedure. And it goes on at paragraph 31 to say that the General Court was therefore correct in holding that in the absence of a final decision of the Commission closing the formal investigation procedure, the effects of the decision at issue endured so that the City of Lübeck retained an interest in bringing proceedings seeking the annulment of that decision, as there could have been other consequences such as the recovery of any aid which had been granted during the City of Lübeck's period of partial ownership. My lady, my lords, the significance of Deutsche Lufthansa principles are clear from the judgment of Mr. Justice Blair, which I needn't take you to because they are taken over in the judgment of the Court of Appeal, which is in the core volume electronic file, page 4648. Where under the heading, the judge's decision, that's page 16 in the internal numbering of the bundle at tab 10, the Court of Appeal reproduces a substantial part of Mr. Justice Blair's judgment, which links the Deutsche Lufthansa case to the principle of sincere cooperation, and that provides the background as to why the Court of Appeal dismissed the Micula's reliance on CAPFA principles, which was their main line of argument before the Court of Appeal, where they said respect for the principle of legal certainty meant that the existence of the decision, which they said came later than the award, meant that the award was res judicata and couldn't be called into question by the decision. And the Court of Appeal picks this up at paragraph 91 of the judgment, which is in the electronic bundle, page 4660, page 28 internally, where the court recalls, consistent with the judgment of Mr. Justice Blair, that control of state aid is a fundamental principle and that the assessment of the compatibility of state aid is an exclusive competence of the Commission. And reference is then made to the judgment in Klausner, paragraph 92.
Sorry, what's the paragraph number?
91.
It's paragraph 91, my lady, going on to paragraph 92, which is on the next page, 4661.
Thank you.
Where, with reference to the judgment in Klausner, the court recalls that there's a risk of the effective application of state aid law being circumvented or frustrated by the principle of res judicata. And the Court of Appeal then concludes at the bottom of that page, paragraph 100, in our judgment, this is accordingly a case in which the CAPFA principle cannot be relied upon. It must yield to the need for the effective application of EU state aid law. My lady, my lords, CAPFA might have had some traction for the Miculas in a different context, but not here. It had to yield to the rigour of state aid rules, and we submit the same applies here. I should touch briefly on Article 351, where much of the debate seemed to be conducted in terms of interests of non-member states. But Article 351 is in stricter terms, and we have to pay regard to the primary text. And Article 351 is in the primary authorities bundle number 1. It's at tab 3, page 42 electronically, and as has already been shown by my learned friend Mr. O'Donoghue's submissions, it's based on the principle of rights and obligations, not of interests, and it means that it's not engaged if a non-member state only has an interest in the performance of treaty obligations by a member state, but only if it has a right to such performance. As a derogation from the normal rules of the treaty, it's to be construed strictly, and we submit it doesn't apply here. I think in the interests of time, I'm going to have to refer the court to one of our submissions before the General Court in the direct action against the decision in case T70415, where our rejoinder is to be found in the appendix part 2B, at tab 24 in the volume, page 801. The electronic number is 5438. And they're set out in paragraphs 38 and 39 and 40, going over the page onto 5439, are the Commission's submissions, which are to the effect that a right can only arise for an state which is able to...
Sorry, I didn't hear that.
I'm sorry, my Lord. The thrust of these submissions in the Commission's rejoinder, in this submission to the General Court, is that a right can only arise for an ICSID state which is able to invoke diplomatic protection for its nationals. So in this context, the right is that of Sweden and the obligation is that of Romania. Now, as regards the risk of conflict in the debate over Article 351 between ruling by this court and the European courts, we submit that risk is there, as we've submitted in our written case, and we would in particular draw attention to the fact that the Miculas seem to have made a concession in that respect. On day one, my learned friend Mr. Mitri accepted that the European courts can and do determine this type of point, an Article 351 point, in the context of a direct action. That's a retreat from the position taken in the claimant's written case, paragraph 149. That's in the electronic bundle, page 4594. It's the core bundle, tab 8, where the second to fifth claimant submitted that whether the United Kingdom owes obligations to non-member states is only for this court to determine. That, we submit, renders untenable the argument about the absence of a risk of conflict. That in turn...
Why do you say we're concerned with diplomatic protection here as opposed to the direct rights of states and obligations of states?
Because in order to identify what constitutes a right for the purposes of Article 351, we say that a right can only be invoked by Sweden in this context. It is only Sweden, if another ICSID state failed to enforce the award, we say that only Sweden could bring an action in the international court to enforce that.
That would be not in respect of the protection of its nationals, but in respect of the infringement of its own right under the Convention.
My lord, yes, but it would be acting, in effect, on behalf of its nationals whose rights had not been respected.
But in a case like Levy, for example, which was concerned with the prosecution of a French employer for, in respect of conditions of employment of women in France, which didn't comply with the ILO convention, there was no involvement in the facts of the case of any other country whatsoever, apart from France. But the fact that the ILO convention was a multilateral treaty was enough to engage Article 351.
Well, so it seems, my lord. I would submit that the reasoning in Levy is terse in the extreme. What your lordship has described is the understanding that we have of Levy, but there's very little that is explained in Levy about that. Yes, it seems to have been taken for granted that Levy implied multilateral rights and obligations. So, my lords, if I return to the issue of the risk of conflict, that, of course, raises in turn the issue about the length of a stay pending the resolution of proceedings in the Court of Justice.
I'm sorry to interrupt you. I haven't quite counted the numbers of judges, but it's a very large court in Levy, presided over by 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes, 11 judges, including the president and 2 presidents of chambers. I mean, I can't brush it aside.
My lord, no. May well have been the full court in
Yes.
those days. One can't brush it aside, but it doesn't resolve the enigma of how the court reached that conclusion in Levy, because this essential question that has been preoccupying us about identifying who has rights and who has obligations simply isn't addressed at all. It seems to be taken for granted. any delay due to proceedings in the European courts is regrettable, but this is the inescapable consequence of the Miculas seeking to litigate issues going to questions of Commission state aid control through national court proceedings. That leads me to the question raised by my Lord Hodge yesterday about the appeal lodged by the Commission against the General Court's judgment and the imponderable of Article 351 being resolved perhaps later rather than sooner. And in that respect, I noticed that the Micula supplementary case, paragraph 9, which is in the second core bundle, tab 13, the electronic page 17, criticises the Commission for not asking the Court of Justice to rule definitively on the entire case. I must emphasise the Commission has no interest at all in delaying the issues raised, because the Micula case is for us part of a much wider picture of investor-state arbitrations where awards could give rise to state aid. We've so far intervened in more than 80 investor-state arbitrations, and a clarification of the issues raised is of paramount importance to us. But the Commission's experience of involvement in some 1,000 or so appeals shows that it's simply unrealistic to expect the Court of Justice to take over issues that haven't been considered at first instance. That's endorsed by the commentary by Paul Lassock, also a very experienced European court practitioner, which you'll find in the authorities bundle 15 at tab 230. It's almost at the very end, it's the last but one, where I would just draw the court's attention to paragraph 1552. I don't think I have time to read it out, but it is
No, you've only got a minute left,
indeed,
Mr. Khan.
it's entirely consistent with the position taken by the Commission.
So could you just give me the electronic page reference?
I am sorry, my lady. It is supplementary memory stick, page 807.
Thank you.
Well, my lady, on the subject of time, my learned friend Mr. O'Donoghue finished 10 minutes early. The initial division of time was 50-50 between the Miculas and Romania, with the Commission's hour being carved out of Romania's time. Since it is Romania that finished short, I wondered if I might take 5 more minutes, which would still confer an extra 5 minutes on the Miculas, thanks to Mr. O'Donoghue.
Actually, Mr. O'Donoghue finished more than 10 minutes early. But
Yes.
I think you can have 5 minutes, but no more, Mr. Khan.
I'm very grateful, my lady. Well, on the subject of the delay, the debate between Mr. O'Donoghue and my Lord Hodge was very much conducted in the context of the appeal. One shouldn't forget that there is also the reference from the Brussels court, presently stayed, and we have a letter to hand out which explains that it is stayed until the resolution of the appeal. So if the appeal is resolved in the Commission's favour, the Article 351 issue will be determined by the court through the preliminary reference from the Brussels Court of Appeal. I should immediately turn to security. We haven't heard from the Miculas, but I can make some short submissions based on the written cases. Again, I submit it's necessary to go back to the primary law and first principles. In an exchange yesterday with my Lord Sales about Romania's possible course of action, Mr. O'Donoghue explained that Romania has no plan as yet, and indeed there has to be something more than a stayed order for security. But on the other hand, Article 108.3 only refers to a plan. So nothing more than a plan is required to trigger Article 108.3 and the standstill obligation. And if the standstill is triggered by a plan, as follows from the plain wording, this does not leave any room for an act going beyond a mere plan, such as paying security, which in any event appears to give rise to new aid. It's contended by the Miculas in their written case, footnote 44, in the electronic bundle at page 4557, that the Commission's written case doesn't repeat that the security would give rise to new aid. That's a surprising claim because paragraph 31 of our written case, which is bundle page 4609, devotes itself to that very question. I think lastly, I should just address the new case that the Miculas rely on, Mediaset, which is in volume 7 of the authorities at tab 101. It's electronic page 1873. The proposition derived from Mediaset by the claimants, paragraph 40 of their written case, is that national courts are not bound simply to accept the opinion of the Commission as regards the enforcement of a state aid decision. Now that, depending on what they mean by enforcement, appears to run directly counter to Deutsche Lufthansa. That can't be right. There is, I submit, no contradiction, in fact. That's because the enforcement issue in Mediaset is not concerned with the National Court's duty under Article 108.3 to prevent the grant of unlawful state aid, that's Deutsche Lufthansa, but rather is concerned with recovery of aid pursuant to a Commission decision that found an aid scheme to be incompatible with the treaty. It's inherent to an aid scheme that it defines the beneficiaries just by reference to certain criteria. It doesn't have to identify them by name, far less the amount of aid that they're to receive, and therefore it was hardly surprising that the Commission decision was silent on this. The Commission never maintained that the decision included within its scope a specific recovery obligation against Mediaset, let alone how much. The Commission decision expressly leaves that to Italy to work out because of the nature of aid schemes. This is at paragraph 7 of the Mediaset judgment, page 1872 in the electronic bundle. And that eye-catching figure of 0 for recovery, which is highlighted by the Miculas in the 2nd to 5th claimant's written case, paragraph 39, is explained by the history of the matter, because the Mediaset had contested in a direct action the validity of the Commission decision, and it gone as far as to argue that if it turned out that it was assessed as a beneficiary, there should be no recovery of aid. Well, it lost that action, and that prompted the National Court to ask if, in the light of that background, it precluded a nil recovery from Mediaset. Just very finally, my lady, as the court will have seen from our written case, we have indicated that the issues raised, if the court were minded to resolve them against the submissions of the Commission, call for a reference to the Court of Justice. Now, I'm conscious of the fact that we have it on the highest authority that the United Kingdom is in an extraordinary situation with respect to relations with the European Union. As a matter of law and principle, a reference is called for on certain questions, but obviously in the circumstances, this is very much a question for the court to decide. My lady, I'm grateful for the indulgence over time. Those are our submissions.
You should be grateful to Mr. O'Donoghue.
I am, of course, grateful to Mr. O'Donoghue.
And we're grateful to you too, Mr. Khan. Thank you.
Thank you.
My Lady, my Lords, I'm going to respond to the submissions in relation to the point of payment that came up yesterday of the 92 million euros, and then deal with grounds 1, 2 and 3. And then my learned friend, Mr. Demetriou, is going to deal with ground 4 and our new ground 5, and deal with some aspects of security, with me dealing with a final point on security after that. Just so the court has a map of where we're going. Can I invite the court to look quickly at the back of the core volume at page 4795, which is the Commission press release. It's just before the index to the authorities, tab 11, at the very back. 4795, and the criticism was made of the Court of Appeal for not having regard to the fact that this had been paid when making its decision on the amount of security. And I have prepared the figures as far as we can that I promised, and I'll get to those in a moment, if I may. But the short point is that the suggestion that the Court of Appeal fell into error in this regard is without merit on several freestanding bases. And I can tell the court briefly what those are. First, if the court looks at 4795, this press release is dated the 7th of December 2018, which significantly post-dates the Court of Appeal's decision. Second, the issue of payment of the award by Romania was both argued before Mr. Justice Blair and lost by Romania. I'll show the court that. Thirdly, that was not appealed to the Court of Appeal, and the Court of Appeal record the fact that there was no dispute raised by Romania in relation to the sum of £150 million, which we sought on the basis that that was a proper sum to seek for the reasons that the court will see in a moment when we look at the note.
Paragraph number of the Court of Appeals.
My Lord, I'm going to take your Lord. I'm going to take the court through, but I just want you to have the points.
Picture.
Each of them is dispositive, we respectfully say. But I sought to promise the court I'd get an agreed note of the sums involved. I haven't quite got that far, but I have got a note with the word agreed crossed out on it for reasons that I will explain. And the short point is that we can confidently give the court indicative figures of the order of magnitude of the sums in issue, there being no need at this stage to get into much more precise figures. So these amounts and the text in 1, 2, 3 and 4 are effectively taken directly from an expert's report that was submitted to the US court in the US proceedings that have recently concluded. And that gives the figure in Romanian local currency, and I've added dash approx 150 million. That's my own addition, which I've converted at today's rates into pounds sterling. And where the court sees in brackets the sums of approximately 6.375 million in line in number 2, I've just tried to give the court a helpful indication of the order of magnitude of those constituent parts to get to the 8 million there and so forth. So in short, this court can see that the original award at today's exchange rate was of the order of £150 million, we say, and the claimants recovered 8 million, of which Romania has got back just under 1 million in line 3. And on that footing, subject to the contention by Romania relying on the Commission press release, the net sum otherwise due as at the 18th of September, which was the date of the expert's report in the US court, was £285 million. Now, it's fair to take the court to the US decision at the back of bundle 15 at supplemental MS 837. So it's the final tab, tab 231 in bundle 15, authorities bundle 15, supplemental MS page 837. And if I can promise the court that the significance of the sentences I'm just going to direct the court's attention to will become clear when we look at the decision before Mr. Justice Blair and how it was argued. But if the court looks at the end of the bottom full paragraph on 837, the American court noted that the General Court nowhere acknowledged that Romania had satisfied the award. And if we go back to the previous, go up to the top of the page, the end of the first paragraph, it's referring to the Treasury account that the petitioners didn't actually receive any money from. That was a blocked account. And the conclusion there is the funds transferred on March the 9th, 2015 cannot be applied against the award. And then if one goes back a page to 836, there's the other matter of the tax set-offs. Romania cannot rely on them to satisfy the award. And the result of that, if one goes forward to page 839, is that the calculation on the 11th of September made by the US court, as between same parties, is in that second paragraph, judgment entered in the sum of 331 million US dollars, which the court will see as slightly higher than the 356 calculation, and we would be perfectly content with the court to proceed on the footing that the 331 million, or a figure of that broad order, is the correct figure. So the short point that arises from this is that on any view, we submit that the actual money received is of the order of about £8 million, less about £1 million that Romania's recovered. In a conventional sense of it having been paid, that this court might recognise, we submit. Now, that leaves aside the press release on the 92 million. And without in any way wishing to be unfair to my learned friends, Mr. Khan or Mr. O'Donoghue, their position is helpful insofar as they can, but neither Mr. Khan nor Mr. O'Donoghue know precisely with complete confidence what the 92 million is said to relate to. But I think I can help the court on that. And the way to do that is by to look in Appendix 2B, if we may, just briefly, so the court can see one of the arguments being run before Mr. Justice Blair. It's Appendix 2B, 5478. And I should have said, this is the skeleton argument of the first claimant, so our skeleton argument, which begins on page 5454. And it's section H at 5478. Under the heading, Romania has not paid the award. And putting it at its lowest, strikingly, one of the contentions made before Mr. Justice Blair was that, made by Romania, was that it had in fact paid the award in full, and that was the basis upon which registration itself should be set aside. And as a matter of fact, the first claimant himself hadn't received any of the payments that the second to fifth claimants had received. But secondly, the Romanian courts, to their great credit, had been a strong bulwark against the arguments being made that there should be a tax set-off to satisfy the award. And the Court of Appeal in Oradea declared, we see at paragraph, the second numbered point, declared that Romania's purported set-off was null and void, and we said that remains the position. And there were essentially 2 points on that. First, that would be the position in English law, and secondly, Romania hadn't adduced any evidence that Romanian law was different. But in fact, there was also, by way of background, some expert Romanian law to the effect that that was still the position. So the short point for this court is that these points were fully argued. The recoveries in Romania were argued, that was point 3, and point 4 was the special treasury account, which was the blocked account referred to in recital 161 of the Commission's decision, which the court will remember was fairly central to the security appeal before the 18th of June. So that was fully ventilated, and just to save time, I'll just give the court, if I may, in case it's of any interest, I don't think it would be necessary, the reference to the arguments for second to fifth claimants is at 5486, and Romania's arguments on the point were 5531 to 2, and the Commission was at 5536 to 7. Can we just briefly look at 5536 to 7? It's paragraph 6 at the foot of 5536. And that was as regards recovery of state aid already granted through Romania's partial implementation of the award. Romania started recovery proceedings as required by the Commission's final decision. Those recovery proceedings concerned 2 separate partial payments made by Romania. First, Romania set off tax debts owed by the third claimant against the award. Second, 3 claimants successfully enforced part of the award against accounts of the Ministry of Finance. And then it deals with the position in relation, the contended position, in relation to the set-off being annulled. And actually, this is the Commission's own skeleton before Mr. Justice Blair. However, Romania appealed to the Romanian Supreme Court on the issue of whether taxpayers' liability for tax could be discharged. And then a hearing in this case is scheduled for later this year. The appeal has suspensive effect, which we disputed. But I would invite the court to note that the Commission, which has made very strong submissions to this court on the reach of sincere cooperation, is quite languidly supporting a position that the full payment of the award by Romania through tax set-offs is still in full vigour, which is an astonishing position given the reach of the position on sincere cooperation for which Romania and the Commission contend before this court. And it goes over the page. To that end, Romania has started forced execution by provisional seizure, but only against assets of the claimants which are not needed for the current business activities of the claimants. Now, this touches on a point that my learned friend, or touches obliquely on a point my learned friend Mr. O'Donoghue made yesterday, which was this an issue he said that the Court of Justice would find difficult to resolve because it was fact sensitive. It's not a pivotal issue, in fact, at all, but it's the issue of whether they're a single undertaking for the purpose of receipt and repayment of state aid, because that's how they've been treated. And, my lady, my lords, the vice of that, the practical vice of that for us, was that it was possible for Romania to be, on the Commission's analysis, to require repayment from any of C1 to 5 of the full amount received by an individual company by way of tax set-off. So you could go to a small company with limited assets and say, repay us the whole amount of the tax set-off that we've given against a completely different company. And to the great credit of the Romanian courts, they have resisted that. So that is an insight into the argument as it was made. And then one then goes back to the core volume, and one finds that my second point, which was that it was fought and won before Mr. Justice Blair, is made out in Technicolor. And it's at 4734 is the relevant part of Mr. Justice Blair's judgment. It's under the heading of issue 6, which was on page 4734, at the back of the core volume. It's under the heading issue 6, payment, and this was an issue from an agreed table of issues that the parties agreed to try and assist Mr. Justice Blair. Issue 6 is formulated by the parties as follows: must the registration order be set aside because the award has been paid in full? And the 176, which is the key paragraph, the court will deal with the payment issue equally briefly, and there's a reduction at that stage. I think different exchange rate meant it looked more like 9 million than 8 million pounds. Romania, at number 2, offset a portion of the compensation awarded to the claimants, about 66 million pounds at that stage, with by way of taxes. So that's a sum, a substantial sum, argued on the tax offset point. And the finding by Mr. Justice Blair on that disputed issue, as argued before him, is at the top of 4735. And he says the court does not agree because set-off does not amount to payment unless the debt in question is extinguished, which is not the case if the set-off has been annulled. So we won on the point that it had not been paid. And then there's the special treasury account, which is the one that was in recital, the blocked account, which is in recital 161, where again there's a complete absence of reality in our respectful submission to the position adopted. But in any event, it was decided in our favour by Mr. Justice Blair, who rejected that unreal contention. And he says these arrangements plainly do not constitute payment. And then it follows that most of the award remains unpaid. And what he means by most is apart from that bit, which is now probably worth about 7 million, that was recovered but has not been recovered back by Romania. Now, so that's that point, and there's absolutely no scope whatsoever to go behind those factual conclusions, but nor was there any appeal to the Court of Appeal on the premise that his approach was wrong. And the Romania did not appeal on that issue. The relevant skeleton, I won't take the court to it, but we can. The relevant reference is Appendix B 55, Appendix 2B at MS 5588. And there's a passing mention of the payment by way of background in the Commission skeleton at 5616. And the Court of Appeal, the relevant part of the Court of Appeal's judgment, the dispositive bit for our purposes, is paragraph 245, which is MS 692. Sorry, MS 4692.
Paragraph?
And it's the section under paragraph 245, under conclusions, my lady.
Thank you.
This is the general conclusion in relation to security falls under this section. And then if we go to paragraph 248 on 4693, the amount of security which the appellants asked the court to order was 150 million, or such sum as the court may think fit. No argument has been advanced by Romania on this appeal that if the appeal is allowed, the security ordered should be any less a sum than the 150 million sought by the appellants. So there was no actual case advanced as to the right amount. So far from it being fair to criticise the Court of Appeal for not taking into account a subsequent press release of the Commission relating to sums which neither the Commission Court or Romania can identify with any confidence, which can only be sums on which they've already lost and not appealed. Far from that being a fair criticism of the Court of Appeal, the position is absolutely the opposite. The Court of Appeal was absolutely right to proceed on the unchallenged factual findings of Mr. Justice Blair in relation to the amount of award that had been paid. Now, I'm sorry to have taken that much time to deal with it, but it was quite a surprise, and we thought it right that the court should have a clear picture as to the basis upon which we were so surprised. It's right in relation to the, just in passing, in relation to the circularity on the stay, which was one of the reasons, if the court remembers, in Lady Justice Arden's paragraph 130 on page 4668 of the core volume in the Court of Appeal's judgment. It's right to note that the circularity point is halfway down, just over halfway down paragraph 130 on 4668. On the right-hand margin, one can see in, the word in, at the beginning of a new sentence. In addition, given the Commission's decision provides for Romania to recover any amount paid under the award, the benefits of execution at this stage would be entirely circular. Now, I just pause to observe that the Commission itself, and indeed Romania, had no problem whatsoever with potentially catastrophic circularity of a much more acute nature when the boot was on the other foot with the argument about the tax set-off. We respectfully say it wasn't a good reason then, and it certainly isn't a good reason now. May I now turn to some brief points in relation to the convention to respond to submissions made yesterday. It's really to take the convention points as they then find expression in the 66 Act and the Civil Procedure Rules together, but just stepping back at the policy level of the convention. My Lord Reid mentioned yesterday at page 169, line 20, the issue of the consequences of enforcement in other states. And also yesterday, my Lord Reid mentioned the impact for those who have already invested through subsidiaries in reliance on the respect for ICSID obligations within the EU, amongst the EU member states. Now, there is a further practical point and one further legal point in relation to those two matters. The practical point is that when it comes to enforcement, it isn't just the fact that the state in which a party is forced to go to try and enforce, instead of perhaps an EU country, has to bear the procedural burden of that. But there is also an FDI, a foreign direct investment or capital flight impact on that country. Because as soon as a party starts proceedings to enforce in another jurisdiction, the state against whom enforcement is sought has carefully to consider whether to increase or decrease the commercial assets which it has present in that jurisdiction. And that is capable of having a negative economic effect on the jurisdiction within which such enforcement is sought. And no lawyer worth their salt advising a state against whom judgment is being sought to be enforced would not at least be alive to the point that the presence or absence of non-sovereign assets in that jurisdiction is important. So that is another practical impact for those other states and the multilateral dimension, which I think my learned friend Dimitri will deal with a little further. There is a legal point which goes to the point my Lord Reid made about the American subsidiary point, if I may, and that is found in the Eco-Swiss decision, which was cited below, but somehow escaped the bundle on this occasion. Learner friends all have copies already. If I can pass that up. Thank you very much. This is a judgment of the court in 1999, and as the court will see on the large numbers at the bottom, 672.
I don't think we have these numbers.
Oh, I'm sorry. Then the internal page number should be 3082. At the bottom left, the page numbers go from one side to the other side. The question there was, it was raised in proceedings brought by Benetton for a stay of enforcement of an arbitral award under the New York Convention, ordering it to pay damages to Eco-Swiss China Time Limited for breach of a licensing agreement concluded with the latter on the ground that the award in question was contrary to public policy within the meaning of the Civil Code of Procedure in the Netherlands, by virtue of the nullity of the licensing agreement under Article 85 of the treaty. And my lady, my lords, can I just say this, that until the interest in a widespread issue that Mr. Khan referred to from the Commission relating to bilateral investment treaties, this was understood to be the position. And the short point is that the competition provisions find expression when there is an arbitral award being challenged through the public policy exception. So, and that's absolutely clear, and we can see it on page 3093, which is about 3/4 of the way through, paragraph 37, it follows that where its domestic rules of procedure require a national court to grant an application for annulment of an arbitration award, where such an application is founded on failure to observe national rules of public policy, it must also grant such an application where it's founded on failure to comply with the prohibition laid down in Article 85, which was agreements and concerted practices, but the same point applies to all competition provisions. And the court reaches the conclusion, it looks at the conclusion in paragraph 38, because, of course, there is a public policy exception in the New York Convention through which the competition issues can find expression in the domestic setting in accordance with the convention, and reaches the conclusion at 39 that for the reasons stated, the provisions of Article 85 of the treaty may be regarded as a matter of public policy within the meaning of the New York Convention. And my lady, my lords, the reason is, I'd refer the court to that, is probably obvious, but that is the very public policy exception which was deliberated and consciously excluded from the scheme of the ICSID Convention. In relation to the passages referred to by my learned friend in the commentary yesterday, could I invite the court to look at Authorities Bundle 13, which has the commentaries in it, and first of all at tab 193, MS 4155.
This is Schreier, is it?
This is Schreier. I'm so sorry, my lord, yes. And under final judgment of domestic court, as a heading on 4155, which, of course, the court will remember has followed finality and non-reviewability in the previous section at 4152, and the exclusion of ordre public and the compromise of restricting it to pecuniary obligations only on 4153. We've got a discussion of finality, and we'd respectfully simply say this to the court. It's a fairly straightforward submission that obviously it's the text of the convention that governs. But you do have to read Professor Schreier's commentary as a whole rather than taking out particular sentences from it. And one can see that the context of this is actually all about sovereign immunity. And we see that elsewhere as well. So the final judgment point, if we look at the third line in paragraph 88, Mr. Broche explained that this would leave the rules on state immunity from execution unaffected.
Sorry, the last line of...
It's the top line of 88, my lord, at the top of page 4155.
Thank you.
And it's the reference to a final judgment of the court in the state where enforcement is sought was contained in the preliminary draft and all subsequent drafts. Mr. Broche explained that this would leave the rules on state immunity from execution unaffected. And then we then see the quote that Professor Schreier thinks is important, which is the bit of the report referring to the doctrine of sovereign immunity at paragraph 43. And one really does have to not extrapolate from that beyond the actual context which he's dealing with. And at the bottom of the page, is the paragraph my learned friend went to briefly, which reads, the fact that Article 54.1 assimilates ICSID awards to final judgments of domestic courts implies that enforcement may be resisted in countries where national rules provide for an exceptional refusal to enforce judgment. And there's only a reference there to an article by two American lawyers. Though this possibility was already acknowledged during the convention, and then referring to Broche, who we've seen what he had in mind, it's not yet been relied upon in practice to defy recognition and enforcement of ICSID awards. Instead, past attempts to resist enforcement have relied upon immunity from execution, see Article 55. So, an Article 55 is, of course, the sovereign immunity provision. So, pausing there, the uniform practice has been to treat it as only subject to sovereign immunity. And that's supported by the very paragraph my learned friend relies on. But when we go back, if we may, to the report of the executive directors of the convention, which is in the previous tab 192 at 4106, it's recognition and enforcement of arbitral awards. Dealing with Article 53 at paragraph 41.
So I
And
have
then-
your page reference.
4106, my lady.
4106, thank you.
4106.
Sorry, you did say what this document is.
I'm sorry, my lady. This is the report. It begins on 4096. It's the report of the executive directors of the convention. And it's the document from which there was a partial quotation from paragraph 42 in the Schroer extract we were just looking at. So the quote from 43 is at 4155 in Schroer, and this gives the court the paragraphs all together to get context. And one can see there, 42 says, subject to any stay of enforcement in connection with any of the above proceedings, in accordance with the provisions of the convention, the parties are obliged to abide by and comply with the award, and Article 54 requires every contracting state to recognise the award as binding and to enforce the pecuniary obligations imposed by the award as if it were a final decision of domestic court. So, no real scope there in the executive director's mind for parsing or atomising that part of the convention in section 6, so that 53 and 54 have no correspondence between the two. And then it goes on to explain the relevance of domestic procedural law because of the different legal techniques followed in common law and civil law jurisdictions and different judicial systems found in unitary and federal and other non-unitary states. Article 54 does not prescribe any particular method to be followed in its domestic implementation, but requires each contracting state to meet the requirements of the article in accordance with its own legal system. And over the page, the rest of 43, the bit that my learned friend referred to ends with, it does not require them to go beyond that and to undertake forced execution of awards rendered pursuant to the convention in cases in which final judgment could not be executed. You read on, in order to leave no doubt on this point, Article 55, which is the sovereign immunity one, provides that nothing in Article 54 shall be construed as derogating from the law in force in any contracting state relating to the immunity of that state or any foreign state from execution. And so, I think probably final point on this, against that background, is absolutely no surprise at all that when we go back to Professor Schroer at 4162, it's the back of that tab, 193, 4162, immediately below the reference to paragraph 42, which I've just taken the court to give you context of 43, it's no surprise that Professor Schroer then says the drafting history and the context of 54.3 make it clear that the laws of the enforcing state that govern execution of an ICSID award are of a procedural nature only. Article 54.3 does not detract from the obligation of every state party to the Convention to enforce awards. In particular, the laws of the enforcing state may not serve as a standard for the review of awards. Article 54.3 does not affect the finality and non-reviewability of the awards. So, we respectfully say, when you read the Convention correctly and completely and as a whole, you get one answer. When you read the whole of the report and the relevant sections, you get the same answer. And when you read Schroer as a whole, you get the same answer, which I think all roads lead to Rome, I think was my submission yesterday. There's one footnote in relation to the Convention, which I feel just bound to draw the Court's attention to, which is there is an academic debate in relation to which my learned friend and Mr. Mitri and I have taken a very slightly different position as to whether execution is distinct in the Convention from enforcement. And it's really a distinction without a difference. The problem is, and Schroer recognises this, that the French and Spanish texts don't distinguish between enforcement and execution and use the same word. And Professor Schroer says so. A triad of concepts of recognition, enforcement, and execution isn't useful in the commentary. But it actually doesn't matter which words you use, because the Court will appreciate from the submissions I made yesterday, this is a prisoner to the functional components of the Convention and the areas in which they make exclusive provision. So it doesn't actually matter how one refers to these matters as execution or enforcement. The question is what functional powers are left to the domestic court. And in relation to that, can I just briefly address a couple of points made by my learned friend yesterday, Mr. O'Donoghue, which we respectfully say require an answer and have a ready answer. There are 2 points. One is temporary and permanent, and the other point is the court's powers. And the short point on temporary and permanent is that on page 132, that's the first actual page of the transcript yesterday, at line 24, my learned friend, Mr. O'Donoghue, said nobody is seeking a permanent injunction. And over the page at 137, so that's the second large A4 page, 137, 23 to 25, and my learned friend makes the point that it has temporarily stayed its enforcement and put in place a facility whereby that stay can be lifted if circumstances change. And there are two points in response to that. First, my learned friend's own written case before this court says that there is power to grant a permanent stay. And secondly, the point on the temporary stay is this. The learned friend's submission is that there's a facility to ensure the stay can be lifted if circumstances change, as the Court of Appeal provided. Well, what circumstantial change would be of greater significance than the annulment of the Commission's decision on the basis that it had no jurisdiction and varies? And if that doesn't change it, the reality of the contention which we respectfully submit, the learned friend was quite properly driven to as a matter of logic in his written case, that this court's got a power permanently to stay, becomes very acute and stands out in sharp relief. So we respectfully say that is really what is being said. And the second point is made in two places by my learned friend, two facets of the second point, in relation to the court's powers. And that's page 136 of the transcript yesterday, so on page 2 also, at lines 6 to 9, which is, it's really lines 4 to 9. My learned friend says, we say it'd be surprising that in a convention that does not touch on national procedural rules in any way, according to the Micula parties, all of the national court's usual procedural powers will be disabled, save in the very narrow exception they admit of under Article 53. Now, we respectfully say that's not our submission at all. It's not our submission for two reasons. The first reason is that the convention does touch on national procedural rules because of the lex specialis argument made out yesterday, because it provides, the effect of it is to constrain the exercise of any procedural powers so that they don't conflict with the convention, because otherwise that would breach the obligation under Article 69, as well as the express scheme and express provisions of the convention itself. So it does touch upon national procedural powers, and it would be absurd to say that in doing so, it disables all other powers and procedural rules. Because of course, that's the whole point of the commentary we've just seen, is that every country will use its normal domestic law procedures, and if someone's got to file a witness statement, then they've got to do it in accordance with the civil procedural rules for that purpose. So we respectfully say, it is a mischaracterization of our case, but it's a significant one because it reveals the paucity of the argument against that analysis. And there is, we respectfully say, no answer to the careful analysis of the procedural powers relied upon by the Court of Appeal, which I addressed the court on yesterday. There's no answer anyway, but also no answer was given by my learned friend. And what we have at page 138, lines 20 to 23, we say a stay is part of the court's general case management powers in this context over the process of enforcement. So I think at that point we're getting back to Rule 3, I think, CPR Rule 3. We respectfully say the case against, that's even more general powers trying to oust the very specific powers we identified yesterday. So that does not answer, we respectfully submit, the lex specialis argument at all. Just in relation to the note that was provided yesterday on CPR 62.21, it wasn't immediately clear to us what the effect of the note on the submissions was intended to be. I thought it might be helpful if the court had the statutory instrument, which originally introduced the forerunner rules under the RSC. And there's essentially one short point, which in a sense anticipates a case which I'm not sure has been clearly made out against our lex specialis submission. But it's just so the court can see the statutory instrument itself. So this is the 1968 SI 1244. And I mean, none of this will be unfamiliar to the court, so I'll take it very quickly. But the recital at the top, we, the Rule Committee of the Supreme Court, being the authority having for the time being power under Section 99(4) of the Supreme Court of Judicature Consolidation Act 1925, to make, amend, revoke rules regulating the practice and procedure of the Supreme Court of Judicature, hereby exercise those powers, and then importantly, and all other powers enabling us in that behalf as follows. And over the page, this jumps ahead to the relevant part, which is under part 3 of the SI. So this is not the complete SI. There's all sorts of other things introduced. And the court can see at number 16 what was added to the end of Order 73, which is obviously the RSC precursor to the Civil Procedure Rules, in functionally identical terms as regards the Convention. And then the explanatory note at the back, the second paragraph at the bottom, the miscellaneous amendments in Part 3 make provision for the service of foreign process in this country under the Convention signed at The Hague on the 15th of November 1965, the enforcement of awards under the Arbitration International Investment Disputes Act 1966, Rule 16, which is the one I've just taken the court to. So it's absolutely clear that there is absolutely no foundation for any analysis that traces through the difference in nomenclature of the procedural rules of the High Court. There's no foundation in that exercise for displacing the lex specialis argument in relation to 6221.5. That's that short point. As regards the approach to the exercise of powers, I just very briefly mentioned to the court that in the core bundle, in Mr. Justice Blair's judgment itself, at 4747,
What's the paragraph?
Oh, I'm so sorry. It's 23 little 3. At the foot of the page, this is where he is deciding not to grant security, just to give it context, but subsequently overturned by the Court of Appeal. And he addresses the time point and the Commission's estimates, which obviously the Court of Appeal deal with in quite strong terms in their judgment. And then over the page at 4748.
Look, I'm sorry, I am working from the hard copy in Appendix Part 1, which is why I don't have the...
I'm so sorry.
116.
Internal 116. It's the final page. MS 4748 is 116 of...
No, it isn't. I don't think...
It is in ours.
Oh, right, I see, yes. So you're looking at paragraph 24, are you?
Just above, it's the end of 23, little
Right.
3.
Thank you.
And one sees more, carries on from the previous page more speedily than had originally been anticipated. And then this is a welcome development, since delay in resolving this matter runs counter to the policy of the effective resolution of investor disputes through the ICSID process, which all relevant states concerned in this matter have signed up to. So we respectfully say, even at the stage of Mr. Justice Blair's decision, there was a recognition of the relevant policy in relation to the enforcement of those judgments, which should inform the exercise of any discretion that the court does in fact have in furtherance or in support of enforcement of an award. There was one particular point just in relation to the General Court's decision in tab A14.
Sorry, the reference again, please.
Sorry, it's A14 at it's A14 at supplemental MS 494. And it touches on a point which I feel, in fairness to Lady Justice Arden, because I was obviously critical of going behind the award in her reasoning for the stay. In fairness to her, a lot of the time in the Court of Appeal was spent looking at the Commission's decision, and one sees at paragraph 72 a point which the General Court overturned, which related to recital 151 in the Commission's decision, where the Commission in its recital said that it did not accept that the Micula parties were entitled to have legitimate expectations, flatly contrary to the finding of what the ICSID tribunal had found. And that was one of the premises behind the General Court's, behind the Commission's decision, and on which the General Court effectively took a strongly different view. And at 72 it says, secondly, it should be noted that in that regard, that in the arbitral award, the arbitral tribunal concluded that by repealing the EGO incentives prior to 1st of April 2009, Romania had undermined the arbitration applicants' legitimate expectations and had failed to act transparently towards them. Therefore, the repeal of the EGO incentive constitutes the event giving rise to the damage for which the compensation at issue was awarded to the applicants in the arbitral award. That will briefly inform some brief submissions just to be made at the end in relation to Sole Bone on security. But those, in a nutshell, are the submissions in relation to the convention and the rules. Very briefly, on the section 2 point, we respectfully say that the submissions made on behalf of Romania and the Commission do not actually address the anterior question of English law as to the delineation of conferral by the 1972 Act by Parliament. And it is not good enough to refer back to Article 351 in that respect. What the anterior question of English law calls for is a completely traditional interpretation of the 1972 Act having due and proper regard to the treaty which it was expressly implementing. And in that respect, we respectfully say that Article 351 is absolutely clear and would have been clear to parliamentarians on all sides of the House when they were considering the advantages and disadvantages of passing that Act. So we respectfully say the mere fact that Article 351 is in the treaty does not detract from the argument. Indeed, it supports the argument because we don't have to infer Parliament's intention as we would have to if there wasn't that express reservation. My lady, my lords, unless I can help the court on those points, I'm going to pass the baton to Mr. Mitru.
Thank you, Mr. Green.
May it please the court, I'm going to first of all make some submissions in reply on grounds 4 and ground 5, the new ground. And then I'm going to respond to my learned friend's case on security, and I'll approach it in that order. So I'm going to start with Article 351, ground 4, and I will address briefly first Mr. O'Donoghue's submissions on whether this case engages obligations towards non-member states. I think I can take that quite quickly. And second, I will address the question of whether this court is precluded from determining the question because of the Luxembourg proceedings. In relation to the first point, we've made our submissions in opening, and I think that the position's been well trodden in debate with the court. But essentially, we say it's clear that on its terms, the convention is premised on a system of mutual obligations between the signatory states. And this is for a number of reasons that I think have now become clear. First of all, there is the point about the burden of enforcement. And Mr. Khan's submission earlier that there are some 80 awards which the Commission is intervening in EU member states to prevent enforcement in respect of, only serves to underline that point, because in those circumstances, it's crystal clear that in cases such as this, and the 80 cases which are awaiting resolution of this case, that the burden of enforcement is going to fall on non-member states. Secondly, the point which was highlighted by Lord Reid in the course of argument yesterday, which relates to the position of investors. A key purpose of the Convention is to encourage investment by providing investors with reassurance that a monetary award can be enforced in the territories of all contracting states. And that purpose would be frustrated if, as here, the courts of EU member states do not enforce awards or at least place lengthy stays in the way of enforcement of awards. And then thirdly, the point Mr. Green made a little bit earlier, which relates to the movement of assets. Now, Mr. Khan said this morning that it's not good enough just to point to an interest. That has to be reflected in a right, and he's correct to say that Article 351 talks about rights. But where he's incorrect is to say that the rights which are conferred are only rights of diplomatic protection conferred on the member state of nationality of the investor. That submission is wrong. There is no basis for it in the Convention. And we see Mr. Broche say otherwise, and if I could just take the court to that, it's in Authorities 13, tab 185, and it starts at MS 3942. And the page that I want to refer the court to is at 3949. And halfway down the page, you'll see a passage which says this: refusal by a contracting state to abide by and comply with an award in accordance with Article 53.1 will expose that state to two types of legal sanctions. The first is the exercise by the investor's national state of its right under customary international law to give diplomatic protection or to bring an international claim. That's the point that Mr. Khan accepts arises. But then Professor Broche goes on to say, the second sanction is a statutory proceeding under Article 64 of the Convention, which provides for the referral to the ICJ of disputes between contracting states concerning the interpretation or application of the Convention on the application of any party thereto, unless the states concerned agree to another method of settlement. And we say it follows clearly from the text that that second type of right arises on the face of this Convention. And Mr. Khan did not have a good answer to Lord Justice Lloyd Jones' question, which was essentially, why not? Why is this confined only to instances of diplomatic protection?
Just on that, are you going to refer to Professor Schreier's commentary on this? Because it seemed to me at page 4122, Professor Schreier seemed to say something similar to what Mr. Broche says here. I just wondered if I was reading it correctly.
Turn that up. It may be
4122. The reason I refer to
Yes.
it is that I was trying to track back from the Commission submissions that Mr. Khan showed us, where this point is made, that you need a right, there's only an interest in states. Generally.
Yes. My Lord is quite right, and I'm very grateful. So he does seem, Professor Schreier here does effectively take the same position, I see, as Professor Broche. Now, Mr. O'Donoghue had 2 points in response to our submission. He first of all tried to draw a distinction between what he called an abstract interest and a concrete interest. But there is no textual basis whatsoever in the Convention for any such hierarchy of interests, and he was unable to point to any. His second point was that there are 2 stages to the inquiry, and he appeared to submit that even if it can be established that mutual obligations, that duties are owed between all contracting states to a multilateral treaty involving the rights, engaging the rights of non-member countries, that must all be ignored if on the facts of the case, the principal players are nationals or member state countries. And the fundamental difficulty with that submission is that it assumes the answer to the question that the court has to determine. So when he makes his point, he says, well, all of this disappears if actually the case only concerns intra-community relations. But that's entirely circular reasoning, because at his first stage, really the question that Article 351 demands an answer to is whether there are in fact obligations owed to non-member countries. And so we say that also that the case law of the European courts, far from supporting Mr. O'Donoghue's argument, in fact support our analysis. And as Lord Reid pointed out a little bit earlier this morning, the Levy case itself, which has been cited in many subsequent cases, the facts in that case were limited to France. So that was a case, not only an intra-community case on Mr. O'Donoghue's argument, but actually an intra-France case. No other states were engaged at all. And if Mr. O'Donoghue's argument were correct, then the European Court would simply have said that Article 351 does not apply because the matter is an intra-community one. But we know that it did not do that, and as the Court has seen from paragraph 13 of the Court's judgment, an essential basis of the Court's reasoning was that it was necessary to go on to consider whether the rights of non-member countries were engaged. Now,
you can make the same. I haven't gone through all the cases, but the same is certainly true of Evans Medical.
yes.
And that's about the importation of drugs from the Netherlands to the UK. So it's the facts are entirely within the EU, but the reasoning is to do with the objective of the treaty and convention in question as being to establish international cooperation and common standards in order to address a common problem.
Well, that's quite right, and that's why I say Mr. O'Donoghue's reasoning is circular, because he's asserting that these cases are about intra-community relations. But actually, the question that the court has to determine is whether that's really so, or whether, in fact, the nature of this convention means that on the facts of the case, duties are engaged towards non-member countries. And that's why I say that his reasoning is circular. As far as the Commission's concerned, I mean no disrespect to Mr. Khan when I say that although the Commission seems terribly keen on the duty of sincere cooperation when it comes to its annulled decision, it seems at the same time quite sanguine about batting off inconvenient European Court judgments which have been cited many times since. Mr. O'Donoghue also, in terms of the court's case law, placed reliance on the RTE case, the McGill judgment. And I would like to briefly take that up. His point was that the Article 351 argument did not prevail in that case. And essentially his point was that was about the Berne Convention, which is a multilateral convention. And so it goes to show that a similar approach should be taken in the present case. Now, the court already has my primary answer to that submission, which is that every convention has to be construed on its own terms. But I have two further points that I would like to draw to the court's attention. The first, if we could take up the McGill case, which is in A Authorities 7, tab 113, and it starts at MS 2048. So it's at the very final tab if you're working from the hard copies of Bundle 7. And I would like to take it up at paragraph 78 and following, which are at MS 2070. And the point I'm about to make relates to the nature of the argument that was made before the court, because that is a relevant factor. And if we take it up at paragraph 78 on page 2070, you see that RTE's submission there. So RTE submits that the convention is part of the rule of law relating to the application of the treaty. In support of that proposition, RTE refers to numerous declarations made by the Commission, which shows that the Convention enjoys broad international support. And then over the page, you see at 79, so this is 2071 and paragraph 79, RTE accordingly takes the view that although the community itself is not a party to the Convention, account must be taken of the rules of that Convention within the framework of community law. And so the argument being made there is a very different argument to the argument being made in the present case, because far from saying, well, there's a clash between the Berne Convention and community law, which Article 351 needs to resolve, the RTE, the litigant in this case, was invoking the Convention as a source of interpretation of the community rules, and its submission was that they were compatible, they could be construed compatibly, which is a different point. But in any event, you see at paragraph 84, and this is the paragraph relied on by Mr. O'Donoghue, that nothing in that paragraph runs counter to our position. In fact, on the contrary, because what's said there about Article 351 is that it's settled case law that the provisions of an agreement concluded prior to entry into force of the treaty or prior to a member state's accession cannot be relied on in intra-community relations if, as in the present case, the rights of non-member countries are not involved. Now, if Mr. O'Donoghue were correct, you would have no need for that proviso. It would simply say, cannot be relied on in intra-community relations, but the court is not saying that at all. The other point that I wish to make is that since RTE was decided, the court has had occasion to consider the Berne Convention in its Luxan judgment. This was argued about in depth before Mr. Justice Blair, and the court will find it in the same volume behind tab 99, starting at MS 1824. And we don't need to go through it in detail, but I would like to show the court two paragraphs, which are on page 1836. The first is paragraph 58, where the court said this. It said, thus, the Berne Convention displays the characteristics of an international agreement for the purposes of Article 351, which provides inter alia that the rights and obligations arising from agreements concluded before January 58 or for exceeding states before the date of their accession between one or more member states on the one hand and one or more third countries on the other, and not to be affected by the provisions of the treaty. So the court's saying there that in principle Article 351 applies to the Berne Convention. And then you see at 62 the reason why Article 351 was not engaged in that case, which was that the agreement allows but does not require a member state to adopt a measure which appears to be contrary to European law. And in those circumstances, the member state must refrain from adopting such a measure. Now, that's not a point that's not the critical point in the current proceedings. But what you have is the court accepting that in principle Article 351 does apply to the Berne Convention. Now, I'm going to move on to deal with the question of conflict, the alleged conflict with the Luxembourg proceedings. And Mr. O'Donoghue took the court to some of the pleadings in the General Court and showed you that a similar issue, and we accept that a similar issue does arise in the Luxembourg proceedings, and his submission is that the duty of sincere cooperation therefore prohibits this court from grappling and determining the Article 351 point now. And he says, imagine if this court were to find that the UK does owe obligations to third countries and that those obligations accordingly take precedence over any conflicting EU law duty. And he says, imagine then that the Commission wins in the CJEU, that the Article 351 matter is remitted back to the General Court, and the European courts, perhaps after a further appeal, ultimately find that Romania did not owe obligations to third parties, so that Article 351 does not apply. Now, he says that that amounts to a potential conflict that this court is now under a duty to avoid, and the consequence is that the court is precluded from determining the point. And we say that this is incorrect, essentially for three reasons. The first is that it follows from Crean, that I took the court to in opening, I don't need to go back to it, that the issue is not precisely the same, the issue before this court is not precisely the same as that before the European courts. Now, Mr. O'Donoghue asserts that it is the same legal question, but that's not the test, because the question in Crean could also be so described, because the case in Crean concerned the application of the same treaty provisions, namely Article 101, to agreements that were materially identical, and the only difference was the parties. And so one could characterise that as the same legal question. But the critical point in Crean, and we see this in Master Foods, explained particularly well by the Advocate General in Master Foods, is that the conflict needs to be, in order to give rise to the duty of sincere cooperation, needs to be a precise conflict on the precise point of law between precisely the same parties. And the reason for that is because the rationale underlying this principle is the need to avoid a breach of legal certainty. And we saw that both from Article 51 of the court's judgment in Master Food and also from the other key European authority that Mr. O'Donoghue took the court to, which is de limitis. Both of them emphasise that the rationale is the need to avoid a breach of legal certainty. Now, in the present case, the differences are, if anything, more marked than the differences in Crean, because what is at issue in Luxembourg, if we ever get to that point, is Romania's obligation as the state to which the award is directed under Article 53 of the Convention. And what is engaged here is the UK's obligations as the state in whose courts the award is being enforced under Article 54 and 69. So we're looking at different legal provisions. And so we say that for this reason alone, that the points are not identical, applying the principle in Crean, which in turn applies the principle in Master Foods, there is no conflict which triggers a duty on this court to refrain or precludes this court from determining the question. The second reason relates to the nature of the issue, and this is an important point in my respectful submission, because even if Mr. O'Donoghue is correct that it's achieving consistency in a broad sense might be desirable, the European case law makes clear that the issue at stake here, which is the scope of the United Kingdom's obligations under the ICSID Convention and whether duties towards non-member countries are engaged, that issue is one for the national courts and not for the European Court. And that it's clear why that's so, and the Advocate General in Evans Medical, Advocate General Lentz, I took the court to that in opening, explained very clearly why that's so, and we see it very clearly in Levy, which was a reference, and where the court batted back that question to the national court, and we see it in many cases after Levy, some of which we have referred to in our written case. And so that's why in the reference procedure, the point is not decided by the European Court, but is sent back to the national court to determine, because it's a point which is within the expertise of the national court and not within the European Court's expertise. Now, Mr. Khan says that I've rowed back from my written case in accepting, he calls it a concession. It's not a concession, it's my submission as to what the law is. He says I rowed back from my written case in which we say that the European courts never consider this point at all, and he refers to paragraph 149 of my written case. His point is incorrect, because if he went on to read paragraph 150, we make precisely the point that I've made orally. I don't ask you to turn it up now, but we do accept, for example, in infringement proceedings, where the Commission is bringing an infringement action against a member state for breach of EU law, and a member state raises, by way of defence, its need to comply with a conflicting international obligation, such that Article 351 is engaged, then of course, in those types of proceedings, the European Court has power to determine the point. But as I sought to explain to the court in opening by reference to the Slovak Republic case, even in those cases, it's notable, we see that very clearly in the Slovak Republic case, notable that the European Court defers to the position of the member state concerned. And that's consistent with its approach in the reference procedure, as we see in Levy and the other cases. And so our simple point is this: in those circumstances, in circumstances where Levy tells us that this court would be unable to make a reference to the CJU on the point, because it would just be batted back to this court would be told, well, that's a question for you. In those circumstances, why should this court be prohibited from determining the question? And it goes back to an observation in my respectful submission made by Lord Hodge earlier in this hearing, which is, does my learned friend accept that the duty of sincere cooperation is a two-way street? And he did accept that, and of course it's a two-way street. And one might expect that on this issue, an issue where the European courts have said quite plainly the particular question at stake is a matter for the European courts, they might be assisted by a determination from this court as to the construction of the ICSID Convention, a convention to which the UK is a party and the EU is not a party.
And one could imagine that the Commission could start infringement proceedings against the UK if, for instance, this court doesn't grant a stay and the Commission says, well, that's in violation of duty of sincere cooperation. So I'm not sure that there's a sort of pure divide between reference cases or for the domestic court and infringement cases, because the two could go into one stream.
My Lord, we address that point that my Lord's just raised in our written case in some detail. I'll find the reference in a moment. But one of the points that we made is that this court, in the case of Pat Malnice, rejected that point. So the submission was made, well, there might be infringement proceedings at a later date brought by the Commission. And so that somehow triggers the duty of sincere cooperation. And this court rejected that because those proceedings weren't on foot in the event they didn't materialise. And so this court did not feel constrained from interpreting the point of community law, of EU law. And, my Lord, I will, with the assistance of those behind me, just find for your Lordship certainly the references to where we deal with precisely that point in our written submissions.
Suppose, Mr. Mitriou, that the case against you would necessarily involve that the EU courts would have the power to make a definitive ruling on the extent of the obligations of the United Kingdom under treaties with non-member states.
Is my Lord asking that suppose that the issue before the European courts was not Romania's obligations but the UK's obligations?
Yes.
Well, my Lord, that would be a trickier position. I think that in those circumstances, the logic of the European Court's reasoning is that ultimately the matter is one for the United Kingdom. And one would hope in those circumstances that there's always the ability of the United Kingdom to intervene in these proceedings. And so at the very least, the United Kingdom's voice would be heard in that way, by way of an intervention.
But it would be a matter for decision by the European courts and not by courts in this jurisdiction.
Yes, and that's a difficult point, because the question then arises, well, what happens then if a decision is made by the European courts, let's say taking account of an intervention of the United Kingdom, and then the point is raised before this court, who ultimately has the right to decide this? And we say, well, ultimately, this is a question for the English courts, and the European Court has said that. And so one would very much hope that in circumstances where the European Court is faced with determining the point in, say, an infringement action, that it would practically apply its duty of sincere cooperation, as it did in the Slovak Republic case, where it deferred significantly to what the member state there was explaining the position to be. But you're correct. We don't have to, in this case, deal with that more tricky point, because the issue is not exactly congruent.
I just ought to say that it's apparent to me that two people behind you are rather anxious to
I'm so grateful, my lady.
attract your attention.
So I think the point is that goes back to Lord Sale's question, and I've very helpfully been given the reference to the section in our written case. And if I could perhaps ask the court to turn it up. So we're in the core volume, tab 8, paragraphs 150 to 153, which are internal page 60. I hope you have the same internal pages as I do. I've rather feared that my lady was indicating that you didn't, but it's MS 4594. And so we make the point at 150 that no infraction proceedings are in contemplation. And secondly, at 151, we make the point about Pat Malnice, which you have in the authorities bundle. I don't think that it's going to be effective time-wise for me to take the court to it, because you see exactly what the point is there. We've extracted it.
And I remember it well.
Great, my lady, yes, of course.
One of those cases that's some are more memorable than others, and that was particularly memorable.
Yes, thank you very much.
I was going to give a third reason why the duty of sincere cooperation does not preclude this court from determining the point, and essentially, in a nutshell, that's remoteness. Because we're not in the situation envisaged by Master Foods, where what one had was a decision, a pending application for annulment, which everybody knew would determine the very legal point that was before the Irish court. Here, we've made the point that the Article 351 issue, in respect of Romania, may never, ever be determined by the European courts in these proceedings. And if it is determined, then a final decision is potentially a long way off. And we say that there has to be some limit to the application of the principle of sincere cooperation in terms of how contingent and remote the risk is. Now, one short point in this context about Mr. O'Donoghue's submission that the appeal can be expected to take a very short amount of time. He referred to the court statistics, where last year the average time for an appeal was 13.4 months, the average time. Now, you can, perhaps if the court has that, it doesn't matter if not, but one can see that for direct actions, the average amount of time has varied. The average amount of time last year was 18.8 months, and it's varied between 17 and 20 months over the last few years. But this case took just shy of 4 years. And so it's not an average case. This is not an average case. That's my submission. And so it's not safe to say that this is going to take an average amount of time. And indeed, the Commission in correspondence, the Commission's estimate was 30 months. But of course, after that, and I know the court has this point, if we succeed again, then the Article 351 point will never be decided. If the Commission succeeds, we're then a very, very long way off a final determination of the point, which is not the same point and is in any event a matter for the English courts. So, my lady, my lords, those are my submissions in reply on ground 4. I'm going to turn now to our new ground of appeal. This was primarily addressed by Mr. Khan in argument. It is said that despite the annulment of the decision, the duty of sincere cooperation still requires a stay of enforcement, and this is put essentially on two bases by my learned friends. It said first that the duty flows from the suspension injunction and the decision to initiate the investigation, those two preparatory acts. And second, the duty is said to flow from the pending appeal to the CJU against the General Court's judgment. And I'm going to take each of those submissions in turn. So to start with the earlier decisions, the preparatory decisions, Mr. Khan's argument is very simple. He says those decisions have not been annulled by the court, and they are therefore valid and binding, and that they consequently give rise to a duty on the English court not to take measures which conflict with them. And we say that that is fundamentally wrong. It is, of course, true that the preparatory acts have not been formally annulled. Parenthetically, I should say that Mr. Khan wondered rhetorically why it was that our clients had withdrawn their application for annulment in respect of the suspension injunction. And the obvious answer to that, it's probably obvious to everyone, is that it had been superseded at that stage by the final decision. And so there wasn't very much point in continuing, at least we thought, continuing to attack the suspension injunction, when actually what we were facing was the final decision. But we say that even though the preparatory acts haven't formally been annulled, it is incorrect to say that they continue to give rise to binding effects. Because whether or not preparatory acts in these circumstances do continue to give rise to binding effects depends on whether they are tainted by the same illegality as that identified by the European courts in annulling the final act in the procedure. And we can see this very clearly from the main authority relied on by the Commission in its supplemental written case, and I'd like to take the court to it. It's Spain against the Commission, and it's in Authorities Bundle 15, tab 224, and it starts at supplemental MS 725. And I'm going to take the court through this authority in a little detail. Starting at paragraph 1 on page 726, you can see that the case concerned an application lodged by Spain, a direct action for annulment, for a declaration that a Commission decision amending an earlier decision on state aid was void. So that's the context of this case. And then the court will see at paragraph 6 that there was a first decision, this is on page 727, where certain monies, certain funds that had been, or financial assistance that had been paid to an undertaking constituted aid and were not covered by any of the derogations. So we see that at para 6. And then over onto page 729 at paragraph 14, the Kingdom of Spain had brought an application to annul that earlier act, and we see at paragraph 14 that the General Court partially upheld that action for annulment. And we can see at paragraph 16 that in particular it annulled that part of the Commission decision that found that the aid did not qualify for exemption or for derogation, because it found that it should have considered whether or not, the Commission should have considered whether or not it benefited from a derogation. And then moving on to page 731 at paragraph 18, after that application, for that successful, partially successful application for annulment, and after the General Court's judgment, the Commission then addressed a letter to Spain saying what it was going to do. And it says this at paragraph 18, you see the excerpt from the letter. It says that we're preparing a new draft of our decision, which in accordance with the judgment is still open. So it's saying, as the Commission purports to say here, the procedure which was initially initiated, commenced, is still open. And the new draft will be submitted soon. Now, pausing there, we don't, of course, have anything like that in this case. So even though the Commission is saying to this court the preparatory acts are still valid and binding, it has not said, and this is an important point which I'll come back to, it has not said we are now going to reopen our investigation and proceed to find that, that there is part of the award, for example, is state aid. It hasn't said that at all. It appears to be taking its chances in the European courts first. Now, moving on to paragraph 19, the Commission then adopted a second decision to the same effect as the first decision. So despite the annulment, it then considered whether or not the derogations applied and found that they did not, and adopted a decision to the same effect. And then you have, on page 733 at paragraph 25, Spain's argument, which you will see immediately is very similar to our argument that I made in opening in this case. And Spain says that since the nullity did not arise from a mere formal or procedural defect, but from a much more serious error, the effect of the annulling judgment should be held to be total and absolute as far as the measure at issue is concerned. It follows, according to the Kingdom of Spain, that the annulment of the earlier decision, precisely by virtue of the reasoning for its annulment, extends to all preliminary acts taken by the Commission before adopting that decision. The Commission cannot therefore rectify its error by merely adopting a fresh decision, but must, on the contrary, restart the procedure from the beginning. So that's the argument that's made. And then at 26, you see the Commission's argument. So the Commission there says that it can't be inferred that invalidity of the contested measure must extend to the preliminary acts. These are not one of the effects of the contested measure to which Article 174 makes reference, but acts preliminary to that measure. Apart from the case in which nullity of the contested measure is brought about specifically by a defect in the preliminary act, there's no reason why that act could not serve as one preliminary to a new measure adopted to replace the annulled measure. And then you see, interestingly, at paragraph 29, the Commission advancing actually a far more measured argument than the one it's advancing before this court now, where it says that where it looks at the type of defect, the nature of the defect found by the General Court in its annulment, and says that because of its nature, that does not mean that the preparatory acts are also deemed to be void. And then we have, at paragraph 31, a recollection by the court of the Asteris principle that you've now been taken to a couple of times. And you see there that Asteris, the court in Asteris held that in order to implement a judgment annulling a community act, it's necessary, the institution concerned is required to have regard not only to the operative part of the judgment, but also to the grounds which led to the judgment and constitute its essential basis. And then the final sentence is important because, or just reading on, it is those grounds which on the one hand identify the precise provision held to be illegal and on the other indicate the specific reasons which underlie the finding of illegality contained in the operative part, and which the institution concerned must take into account when replacing the annulled measure. The procedure for replacing such a measure may thus be resumed at the very point at which the illegality occurred. And so the key question is, at what point did the illegality occur? That's the key question. And then you see at 32, according to established case law, annulment of a community measure does not necessarily affect the preparatory acts. And we really do place emphasis on the words necessarily, because of course Mr. Khan's submission is a much more extreme one, which is the annulment of a community measure cannot affect previous acts where they have not been themselves individually annulled by the General Court. And we say that is inconsistent with what the court says at paragraph 32. And then at paragraph 34, you see the basis on which, in that case, in the Spain case, the court did not find it necessary to require the Commission to unravel the whole process. And that was because the initial decision to commence the investigation left open did not contain the illegality, which was a failure to consider the derogations, because at that stage it left open whether or not the derogations would be considered. And so what we say is that applying this reasoning, the court has to ask, when did the illegality manifest itself? Well, we say it plainly manifested itself in the suspension injunction and in the decision to commence the investigation. I took the court to those decisions in opening, but essentially the point is this, that in those preparatory acts, both of those preparatory acts proceed on the basis, first of all, that the entire award, ICSID award, is state aid, and secondly, they do not purport to draw any distinction between the pre- and post-accession period. Indeed, the Commission expressly disavows that distinction, and we saw that especially in the decision to open the investigation. And also, I would recall the operative part of the suspension injunction, which you've seen now on a number of occasions, requires Romania to immediately suspend any action which may lead to the implementation of the award rendered by the arbitral tribunal. And so our simple point is that applying the principles laid down by the court in Spain Commission, these preparatory acts are tainted by the illegality found by the General Court. And the investigation is not permissible for the Commission simply to say, well, we can keep the investigation as it was, keep the suspension injunction, those continue to impose obligations, and we can take a different decision, because that would, apart from anything else, be procedurally unfair, because the scope of the investigation was the scope of it was determined on an unlawful basis.
Mr. Mitru, are you asking us to conclude that these preliminary acts are a nullity? And is that a matter within our competence?
I don't have to go as far as to ask you to conclude that they are a nullity, because plainly this court can't formally annul those acts. So I entirely accept that. I entirely accept that. But I'm asking you, what I'm asking the court to do is to reject the submission made by the Commission that they continue to have binding effects which trigger a duty of sincere cooperation on this court to comply with them. And indeed, it would be perverse, we say, if they did impose such a duty on the court, because we know that they are tainted by the same illegality as the General Court found is present in the final decision. And in a sense, one can test the point this way, because let's say that Mr. Khan's argument, if I can put it this way, proves too much, because let's imagine that the Court of Justice finds, not only upholds the General Court judgment, but goes further and finds that the Commission never had any jurisdiction at all in respect of any of the award. Then, in those circumstances, applying Mr. Khan's logic, he would presumably make the same submission to this court, which is that the preparatory acts have not been annulled, and this court is bound by a duty of sincere cooperation to stay the award, because to do otherwise would conflict with those preparatory acts. And we say that can't be so. So it proves much too much. So what I am asking the court to do is to take account of the fact that applying the principles in Spain Commission, these preparatory acts are tainted by the same illegality that's been identified by the General Court, and to find that there's therefore not a duty of sincere cooperation, which requires this court to ensure that whatever it does complies with them. And we can see there's another basis on which Mr. Green reminds me that the duty of sincere cooperation here, we say, requires the court to give effect to the General Court's judgment rather than to these preparatory acts which are tainted. There is another basis on which I put the submission, and this is a response to Mr. Khan's reliance on the ArcelorMittal case, which you'll recall he took the court to yesterday, because we say that that case also supports our position, because what that judgment certainly can't be read as establishing, given the principles that I've just taken the court to in Spain Commission, it can't be read as establishing that preparatory acts must necessarily be presumed valid in circumstances where the ultimate act at the end of the process has been found to be invalid. So it can't be read to say that, because that would be inconsistent with the Spain Commission line of authority. ArcelorMittal itself concerned regulations rather than decisions, and of course regulations are of general effect and are apt to engage the rights of all sorts of third parties. And so one can quite see why in a case like that, the court doesn't say, well, we're going to presume that they're invalid. But what the court did do, and this is an important point, the court recognised, and perhaps we can turn it up, it's at Authorities 14. Tab 208, starting at 385. And I really want to take you to paragraph 66, which is on page MS 396.
Sorry, 14208.
Yes, my lord, so it's 14208 and it's MS 396. And this is a point that was accepted by Mr. Khan. Indeed, he placed emphasis on it, which is that even though in that case the regulations, the separate regulations were not formally annulled by the court, what the court did say was that the institution has a duty to eliminate the illegalities in those other measures. And we saw that also in Asteris paragraph 30, on which Mr. Khan also placed emphasis. And there's a discussion in this judgment about what the Commission had to do to eliminate the illegalities from the regulations already adopted. And our key submission is that the Commission has not done that in this case. And so in those circumstances, it would be perverse, we say, to conclude that this court is obliged to close its eyes to that fact and regard itself as precluded from doing anything that might conflict with those preparatory acts, even though we know that they are tainted by the same illegality and the Commission has a duty to fix them. And the duty of sincere cooperation does not apply in those circumstances. Now, if
the Commission had applied to suspend the General Court's judgment pending the appeal, this argument couldn't arise.
It's
the fact that they haven't.
That's correct.
Allows you to say this.
That's correct.
Yes.
My Lord. And also, I might add to my Lord's point that if the Commission had decided to do what we saw happened in Spain Commission and actually open a new investigation in a way that might be said, arguably, to comply with the General Court judgment. So if it took steps to reopen an investigation and purported, for example, to try and divvy up the award, depending on pre-accession and post-accession and so forth, and we say that's impossible, but if they tried to do that, then we would be in a different situation because the Commission then might be able to say, well, in respect of that portion of the award, which we are now investigating, this court has a duty of sincere cooperation to avoid enforcing the award to that extent, to the extent of that portion. But it hasn't done that. Instead, what the Commission has done, it appears, is that it's elected to pursue an appeal, and in the meantime, the investigation is on ice. And we say in circumstances where the General Court has found that the decision is unlawful, there can't be a duty requiring this court blindly to follow the preparatory acts which we know are similarly tainted. So that, in a nutshell, is our response to Mr. Khan's points on the preparatory act. Both my learned friends also rely on the pending appeal to the Court of Justice. We say to that there is no duty of sincere cooperation engaged on that account because we're not in the master food situation. The question is, and I'm repeating myself, I know, what does the principle of legal certainty require? And that's the rationale for the master foods duty. And it requires this court to avoid an inconsistent conclusion in applying EU law, here EU state aid law, to the same facts. And we see that described in great detail in Korean. But if the enforcement proceeds in England now, nothing this court says will involve this court reaching a conclusion as to the application of the state aid rules at all. And so one isn't faced at all with the clash between determinations on the same point that was what engaged the principle in Master Foods and Korean. because what the court is being asked to do by us is to enforce the award, and if in due course down the track the Commission were to succeed before the Court of Justice and the decision were to be reinstated, there would be no legal clash. All that would be required would be a clawing back of monies that had perhaps been paid out pursuant to the enforcement. That doesn't result in any breach of the principle of legal certainty. And there is no authority that's been pointed to which demonstrates that that kind of practical inconvenience or obstacle is sufficient to trigger the duty of sincere cooperation on national courts. So those are my submissions, unless I can assist the court any further on grounds 4 and on our new ground. I was proposing to turn now to respond to the case on security, if I may. The Romania's case and the Commission's case, in both before Mr. Justice Blair and before the Court of Appeal, was that it was the decision which prohibits the payment of security. So the principle of the duty on the court not to make the security order was said to stem from the decision. And that argument was rightly, we say, given very short shrift by the Court of Appeal. I'll take the court in a moment to the relevant passages of the judgment below. Of course, now Romania and the Commission's case has shifted, no doubt because of the annulment of the decision, and I'm not making a forensic complaint about that. They now say that the payment of security could constitute new aid. So this is a very different point. And we say that in assessing the plausibility of this argument, it is, in our respectful submission, important to bear in mind that it's a point that they could have taken below, but didn't take below. And in fact, the point goes further, because the Commission, in fact, disavowed the argument, and I'll take the court to that in a moment. But I'd like to go first of all to the Court of Appeal's judgment below. And the relevant passage is in core volume MS 687. I'm starting with paras 226 to 227 of the Court of Appeal's judgment. I'll find the internal reference in a second.
It's all right, as long as I have the paragraph numbers, I can find them.
It's in any event 55 in the internal numbering.
That's right. Mm.
So we see that the argument as put was that the Commission decision, we see this from 225, the Commission decision prohibits Romania not only from paying the award, but also from providing security for the award pursuant to a court order. We cannot accept this argument as it does not correspond to what the Commission's decision says, and the Court of Appeal then set out the operative parts of the decision. And the key point, of course, is that the decision prohibited the payment of compensation awarded by the tribunal to the Micula parties. And of course, the security order, which requires payment of monies into court or the provision of a guarantee in the alternative, does not amount to payment of the compensation awarded by the arbitral tribunal, and certainly doesn't amount to any payment to the Micula parties. And that is what the Court of Appeal finds at paragraph 227. And then across the page, the next page, paragraph 231, we see the court note that the Commission has not advanced any reason to seek to justify treating the provision of security as constituting state aid, when asking whether there is a rational basis for treating the provision of security as equivalent to the payment of compensation awarded to the appellants. Counsel for the Commission, Mr. Khan, QC, was unable to offer one. It's not clear to us why the Commission should wish to argue that its decision has an effect for which there's no legal justification. And so no coherent, as you can see, no coherent argument was even advanced before the Court of Appeal. And then at 234, you see the point that I've just summarised, which draws a distinction between what the decision precludes and the security order, which is very different in its effect. And then over the page at 237 to 238, we see the court say, reject the submission made on the basis of the principle of sincere cooperation, because what was said to the court was, well, you have to refrain from acting if there's even a risk. And the court said, rightly in our submission, and we deal with this in our written case, well, the risk point arises where there's no decision yet, because you don't quite know what's going to be said. But where there is a decision, then of course the court is well placed to look at the decision and decide whether or not it does actually preclude this particular order. And the court reaches its conclusion at paragraph 238 and referred to the Commission's argument as a bare assertion that its decision would require the provision of the security sought, would regard it as payment under the award made to the claimants. It says that that's no substitute for a reasoned argument, and no argument in support of that assertion which bears scrutiny has been advanced on the Commission's behalf. So the point was given very short shrift. Now, the Commission's position before this court, I would just like to take you to, in the same core volume, behind tab 3, to the Commission's submissions in support of Romania's application for permission to appeal. This is MS 4291, it's behind tab 3. And I'm not going to take you back to the letter, because you've now seen it several times, the Commission's letter of August 2018. But you see in this document a clarification of what's meant in that letter, and we see this on page 3 in the internal page numbering. And in response to what we were saying, the Commission says this towards the top of the page. It says, any force the respondents' objections might have is removed by the Commission's letter, this is the September letter, of September 2018. Contrary to what the respondents appear to contemplate, this is not a further decision, which is irrelevant to the present matter. The letter of the 7th of September makes clear that the Commission's position is based on the Commission decision. That letter is not therefore a further decision which can be set aside for consideration later. The letter simply recalls Romania's obligations under the Commission decision that is in issue here. And so what's being said is that really, even at that stage, the Commission was putting its case in terms of it being the Commission decision that precludes the security order. And of course, we've seen what the Court of Appeal made of that. Now, despite that position, not only below, but in the written submissions before this court, which refer only very slightly and tangentially to a possibility that this could be new aid, without taking the matter any further at all, Mr. O'Donoghue now says that there are 3 options which would allow Romania, or would allow the duty of sincere cooperation to be triggered, and which preclude the security order. Options 1 and 2 are very similar. The court will recall that Mr. O'Donoghue's option 1 is that Romania could, indeed he says will, notify the Commission of the fact that the security order, the fact of the security order under the state aid procedural regulation, and this would trigger the standstill obligation. And option 2 is to similar effect, because that option is that the Commission could investigate the matter of its own accord, which again would trigger the standstill obligation. And we make the following points in relation to those 2 options. First, we say that this argument is a bootstraps argument of a very unattractive kind, and I want to take a few moments to explain why I say that. The court will have in mind that the order for security requires Romania to pay money into court or provide a guarantee. If we could just pick up our written case, which is in the core volume behind tab 8, at paragraph 61. Here we address the suggestion made but not developed by Romania in its written case. So this is MS page 4557, page 23 in the internal numbering. We address Romania's suggestion that there's a real risk that Romania providing security, even if not prohibited by the decision, would constitute a new aid. Mr. Khan, we say there's nothing in the Commission's written case supporting this point. Mr. Khan fairly makes the point that there is a very brief suggestion, but it's certainly not made concrete in any way, shape or form. We say that it represents a retreat from the position in Romania's grounds that the payment of security would amount to a new state aid. That's what they were saying previously. And then we say that whether or not a particular measure is a new aid is a mixed question of law and fact, and no evidence on the elements necessary to establish a new aid was adduced below. None is adduced before this court. And Romania has not in its written case, and I add, nor has the Commission, provided proper particulars in support of this assertion, and without prejudice to the submission that we can't fairly be expected to respond to it, we deny that it would amount to a new aid, and we note that Romania has made no attempt to show that the provision of security meets the several cumulative elements of the definition of a state aid, including selectivity, imputability to the state, which would be a tricky one for it, because how does one say that a security order gives rise to aid imputable to Romania in circumstances where it's an order of the English court? And then thirdly, a distortion of competition affecting trade between member states. Again, we say another tricky one, because how a payment into court or a guarantee which doesn't actually accrue physically in any way to our client's benefit, but which may help them down the line to enforce, how that can result in a distortion of competition which affects trade between member states, we say is very difficult to understand. There is another point now in light of the General Court judgment, which is, of course, this idea that security might constitute new aid is dependent on the decision being valid, on the award being aid, because it's, in a sense, a contingent submission. Because if the award is not aid, then how can an order for security, which is designed to address prejudice arising from the stay, how can that be state aid? So that's another obstacle in the way of a new aid finding.
The argument against you is that the existence of security would improve your covenant and therefore make it more likely that someone would take a bet on the litigation on the one hand, or might be willing to loan you again, betting on the outcome of the litigation. But I assume your answer to that is, how does that amount to a distortion of competition?
Right, and it's a point which is made by plucking out of context a submission that was made before Mr. Justice Blair, I think by my learned friend, to explain why the order might prove useful. There's no evidential basis that the Commission is relying on. So it's extraordinary, we say, that rather anecdotal point is being used as the basis for saying that this might be new aid. My lady, may I stop there? I see the time. I've got a few more points to make on security, and then I will sit down. It won't take me very long. There will be some time for Mr. Green to make his additional points too.
Yes, well, you started, I think, about 10 minutes early, so you've only got until probably just after 2:30 between you. I'm trying to keep a timetable.
My lady, we will comply.